True Peace, Ken's Derek Chauvin files for new trial in death of George Floyd. Man, peep the slang. Defense attorney Eric Nelson argued that Derek Chauvin's constitutional right to a fair trial was violated. Hey, peep the slang, yo. Ex-Minneapolis police officer Derek Chauvin has filed a motion seeking a new trial in the death of George Floyd, arguing that his constitutional right to a fair trial was violated multiple times throughout the proceedings. Defense attorney Eric Nelson took issue with the judge's refusal to grant a change of venue and decision to not sequester jurors during the trial, among other things, in a 10-point post-verdict filing. The cumulative effect of the multiple errors in these proceedings deprived Mr. Chauvin of a fair trial in violation of his constitutional rights, the filing reads. Nelson argued that it was unconstitutional when the court declined to compel testimony from Morris Hall, a suspected drug dealer and friend of Floyd's, who was with him at the time of the May 25, 2020 incident that led to his death. Derek Chauvin jurors BML t-shirt sparks concerns about trial verdicts. The court abused its discretion and violated Mr. Chauvin's rights under the Confrontation Clause when it failed to order Morris Hall to testify, or in the alternative to admit into evidence Mr. Hall's statement to law enforcement regarding his interactions with George Floyd and presence at the May 25, 2020 incident. Here go the file right here. I'm going to have to. They say to the above named court, the Honorable Peter A. Cahill, Judge of Hennepin County District Court, and Matthew G. Frank, Assistant Minnesota Attorney General. Okay. Notice of motion. Please take notice that the defendant Derek Michael Chauvin, through his attorney Eric J. Nelson, Hallberg Criminal Defense, hereby moves this court for the following relief motions: for an order granted a new trial pursuant to Minnesota R 26.04. One of the following grounds: the interest of justice, abuse of discretion that deprived the defendant of a fair trial, prosecutorial and juror misconduct, errors of law at trial, and a verdict that is contrary to the law. The specific basis for this motion include, but are not limited to: the court abused its discretion when it denied defendant's motion for a change of venue pursuant to Minnesota R. Cram, 2403 and 2502, in a violation of Mr. Chauvin's constitutional rights to a due process and a fair trial. See Shepard Maxwell 38-4 U.S. 33 333 363 1966. It say the court abused its discretion when it denied defendant's motion for a new trial on the grounds that publicity during the proceedings threatened the fairness of the trial. Shepard Supra, such publicity included post testimony, but pre-deliberation, intimidation of the defense expert witness, from which the jury was not insulated. Not only did such acts escalate the potential for prejudice in these proceedings, they may result in a far-reaching chilling effect on defendants' ability to procure expert witness, especially in high-profile cases such as those of Mr. Chauvin's co-defendants, to testify on their behalf. The publicity here was too pervasive and too prejudicial, before and during this trial, that it amounted to a structural defect in the proceedings. See United States versus Hastings, 461 U.S. 499 508-09 1983. Certain errors involve rights so basic to a fair trial that their infraction can never be treated as a harmless error. The court abused its discretion when it failed to sequester the jury for the duration of the trial, or in the last admonished them to avoid all media, which resulted in jury exposure to prejudicial publicity regarding the trial during the proceedings, as well as jury intimidation and potential fear of retribution among jurors, which violated Mr. Chauvin's constitutional rights to due process and to a fair trial. Minnesota R. Criminal 2603. The state committed pervasive prejudicial prosecutorial misconduct which deprive Mr. Chauvin of his constitutional rights to due process and a fair trial, including but not limited to disparaging the defense, improper vouching, and failing to adequately prepare its witnesses. The court abused its discretion and violated Mr. Chauvin's rights under the Confrontation Clause when it failed to order Morris Hall to testify or, in the alternative, to admit into evidence Mr. Hall's statements to law enforcement. Hey man, keep the slang. Hall invoked the Fifth Amendment to avoid testifying and say, but he had made statements to police that were not revealed to jurors, despite Nelson's attempt to have them read in court. Nelson also accused prosecutors of pervasive prejudicial prosecutorial misconduct and alleged that jurors convicted Chauvin on charges that the evidence did not sufficiently support. The court abused its discretion when it submitted instruction to the jury that failed to accurately reflect the law with respect to second-degree unintentional murder, third-degree murder, and authorized use, of force. The filing reads, and he argued that the court allowed prosecutors to lead witnesses during questioning. Okay, in addition to requesting a new trial, Nelson asked for the guilty verdicts against Chauvin to be tossed. Two notable potential areas of conflict were left out of the filing. Controversial remarks from Representative Maxine Waters, D. California, and a jury who was photographed at a Black Lives Matter protest but failed to acknowledge it on the pre-trial questionnaire given to potential jury members. Waters had said she would argue protesters to get more confrontational if Chauvin had been acquitted at trial. And Brandon Mitchell, the juror, was photographed last summer at a Washington, D.C. BLM rally wearing a t-shirt that said, "Get your knee off our neck," a reference to Floyd's death after Chauvin knelt on his neck for nearly 8 minutes on the video. The questionnaire asked directly whether potential jurors had attended protests over the death of Floyd or over police brutality. Mitchell answered no to both questions. He declined to comment Tuesday. Man, peep the slang, yo.